Should I go ahead? Oh, wow, my hair. My hair does not look good. Hello and good afternoon, and thank you for being here. Today we're going to have a special training with Dan Bernstein and Josh Kirschenbaum. Dan is a mediator living with bipolar disorder who adapts conflict resolution best practices to help people have empowering mental health communication while preventing mental illness discrimination. His book, Mental Health and Conflicts, A Handbook for Empowerment, was published by the American Bar Association in 2022. Josh Kirschenbaum is a Harvard-trained mediator and collaborative divorce attorney with more than 20 years of experience working with families, children, and adults with special needs. Josh brings a rare combination of personal experience, professional expertise, and compassion to his practice. Because Josh had a conflict that kept him from joining us today, we will begin with a 20-minute video discussion between Dan and Josh. Then Dan will join to take questions, present some trainings, and share resources that you can use after this session.
Everyone, welcome to today's program on how mediation can resolve disability discrimination and accommodation conflicts. My name is Dan Bernstein. This is Josh Kirschenbaum, and we are co-presenting this workshop. I will come on a little bit more at the end. We're going to start with this conversation between the two of us, and that conversation is going to be about just what we think is important about mediation and working with people with disabilities. First, we will quickly introduce ourselves. I'm Dan Bernstein. I am a mediator. I have bipolar disorder. The reason I became a mediator is because I had noticed that a lot of the problems in my life related to my mental illness were not just the symptoms. And my symptoms were pretty severe. I've been hospitalized 5 times with this condition. But I thought that a lot of the problems I was having had to do with how everyone was talking about me and my mental illness and how difficult it was to integrate because of the stigma. And so I wanted to come up with ways to try to address the stigma associated with mental illness. And to do that, I looked around in lots of areas and I found mediation and I fell in love with it because the core values of mediation are that everyone's choice is respected. It's called self-determination. And that the person who's involved, the mediator, is impartial, meaning they don't take sides and they don't judge you based on knowing you have a mental health problem, et cetera. At least in theory, that's how it's supposed to work. So that's why I became a mediator. And what I found was that in practice, a lot of mediators don't always live up to those values. And so I do a lot of work to try to help people become less biased when they encounter disabilities and more accessible and have fairer procedures. So that way they're not treating people differently if they notice someone with a disability. And that's where a lot of my work is now, is in addressing discrimination issues and best practices. I wear a lot of hats, but the number one is my lived experience as someone living with the disability of bipolar disorder. So that's a little bit about me. Josh, would you like to introduce yourself as well?
Yes, thanks, Dan. So I started out my career as a teacher, public school teacher. I taught 4th and 5th grade in a mixed classroom in a public school outside of Boston, working with children with all kinds of needs. And it was from my experience teaching that I wound up actually transitioning into becoming a lawyer. And my life as a lawyer has always involved working with families, families with children particularly, and families who have children with disabilities specifically. All of my work as an attorney for the first 10 or so years of my life as an attorney was working in the field of special education law. So I worked with families who have kids with disabilities who were in disputes with public school districts over the provision of special education services. So my whole life as a lawyer has been working with helping families navigate the legal system. And the first part of that life, when I was working as a special ed lawyer, that was a very adversarial practice. I was effectively a litigator, and I was helping parents navigate a very adversarial, litigious legal process. And after about 10 years of doing this, it started to feel to me professionally like there were better ways that I could be helping families navigate the advocacy for their children and to help them resolve these disputes that they were having with the public schools. And so I transitioned out of the adversarial practice of law and into the world of mediation. And I took with me into that world, into that practice, my continued interest in working with families who have kids with disabilities. And so I've worked as a mediator, helping school districts and parents resolve disputes. And more recently, working in the context of divorce and custody mediation, helping parents who are going through divorce and who also have children with disabilities and helping them navigate that very tricky, complicated, intersecting labyrinths of being a parent of a kid with a disability and also going through divorce at the same time. And like Dan, I gravitated towards this because it was very clear to me that if you were going to design a dispute resolution process that was well suited for helping in situations that involved people with disabilities, children or adults, that process would look a lot like mediation. And as we're going to talk about during our time today, mediation is very well suited for helping families and individuals and institutions and organizations that are in these conflicts. And there's a lot of reasons for that that we're going to talk about.
Well, that's a great introduction. And I think it's a perfect segue for us to go to our first question, which is we're framing this as an interview with me interviewing Josh. And then afterwards, I'll come on and share some more about the work I do to help make sure people are empowered and it's not discriminatory when parties with disabilities end up going to mediation. But for now, let's go to our first question, which is what is the value of mediation when it comes to parties with disabilities?
Yeah, and Dan, you already started talking about this in your introduction. You mentioned the core concept of self-determination. Party self-determination is one of what we call the four pillars of mediation. These are the core aspects that make mediation what it is. And even though mediation is kind of a varied profession, right? It's a varied process. It's not practiced exactly the same in all contexts and in all situations. There really are these four things that need to be true no matter what. And one of them is that it's a process that really promotes the parties themselves being the ones that come up with the solutions to the problems, that it's their process. It's not a process like going to court where there's an outside decision maker imposing a decision or a solution onto people's conflicts. Party self-determination is something that is inherent to mediation, not just when there's a person with disabilities involved, but when there is a person with disabilities involved, a process that leaves it to the parties to come up with uniquely tailored, well-informed solutions to very unique conflicts involving unique situations. That's the kind of process that you want to have. You don't, when you have a disability or a life or a situation that you're in that's not typical of what most people are going through for one reason or another, you don't want to turn that over to a stranger to basically apply a one size fits all approach to imposing a solution like going to court. Mediation keeps the decisions in the hands of the parties who know the situation the best and who are in the best position to create creative solutions to these unique challenges. The other thing about self-determination is that it's an inherently respectful and humanizing value. It's basically saying you, the parties, are the ones that are capable of resolving this problem yourself. You don't need somebody else to tell you what you should do, what you have to do. And for people who have been disempowered and disenfranchised throughout their lives, a process that respects their autonomy and it respects their knowledge of their own situation and their ability to know what's going to work for them. That's the kind of process that we need to have available, not just for people with disabilities, of course, but especially for people with disabilities. So self-determination is one thing about mediation that makes it very valuable in these types of conflicts.
Yeah, that's great. And I 100% agree with your perspective on that. And I'll add that, self-determination is something that everybody should be getting in mediation and it matters for everyone. But it is especially valuable if you're living with a disability, especially if you've experienced stigma and you're not used to people treating you with that level of dignity and respect and the agency. And there's so much paternalism that people have when approaching people with disabilities or dismissiveness, that sitting with a mediator who's really present and treating you like you have choices just like everybody else can mean a great deal. So thank you for sharing that perspective.
Yeah. And just to add to that a little bit, Dan, if it's okay,
Sure.
the other piece of this self-determination issue is that mediation is a process that allows for that kind of flexibility in thinking and that kind of flexibility in practice. Formal court processes, formal hearings with rules, formal court proceedings with rules are much more rigid, much more institutional, and much less flexible, and much less practically able to be modified and changed. Mediation is a much less formal process. It's a much more homemade process, and so it's well suited for situations where people need and want to be coming up with creative approaches or different approaches or modified approaches to the process itself.
I 100% agree with you at how important it is to be flexible and accessible to people with different needs. And we'll come back to that in a moment when we talk about the kinds of skills that a mediator needs to have to handle these cases well, because not everybody has that accessibility spirit. And so it'll be great to talk about that in a moment. Before we do, let me ask you one other question, which is if you can share some examples of situations that you have seen in mediation where the matter is actually related to someone's disability or where their disability needs become part of the conflict resolution process.
Oh, sure. Well, like I mentioned, given my background, basically all of the conflicts that I've been involved with as a lawyer or mediator, or sometimes both, because I've been a lawyer who's been participating in mediation. I've sort of been in all the different roles. Um, okay, so first of all, this can come up in any type of conflict because all conflicts are human conflicts and any human could have a disability. So let's just start out right away by saying literally any conflict that involves human beings could be a conflict that involves a person with a disability. That said, in my experience, okay, so I've definitely encountered it in the context of special education mediation because there, by definition, the dispute was about the the need to find appropriate educational services for a child with disabilities. So, for example, one mediation that comes to mind involved a little girl who is deaf, and the parents were in a very, very heated conflict with their public school about providing appropriate educational services and appropriate educational placement, modifying the public schools that she was in to enable her to learn as a deaf child. And that conflict very started out very positional. The school district basically saying, well, this is about what we legally are required to provide and we're not required to do. And the parent basically talking about what they felt was best for the child. And, you know, which is very commonly an issue when the conflict involves a person with a disability. Often it's about what does the person need and what does the institution or the other side have to provide. So mediation worked really well in this case because what we were able to do is we were sort of able to get underneath these positions and sort of explore what's really going on here. What's the conflict really about? And what we really came to all understand is that a lot of it was about just simply not knowing, lack of knowledge about what types of supports and services could even be available to this child. What might she need? What might be helpful? And how do you actually do this? And so what started out as a conflict over that seemed to be about, what do we have to do? What do we not have to do? it became a shared opportunity to learn more and to connect with resources of people who actually were very skilled at coming up with adaptations and modifications for children who are deaf. So that's certainly one context. As I mentioned, I also have encountered this in the context of divorce. I can think of fairly recently a mediation that I was involved in as a mediator that involved a couple who was going through divorce, and they have a child with cerebral palsy who uses a wheelchair. The entire house had been modified for the use of the wheelchair, wider halls, modified van, ramps, elevator, all this stuff, very expensive accommodation modifications to the house. And now they're splitting up. And one parent is going to be going to a new home that is not modified yet, anyway. And they don't have the resources to put $100,000 of work into that other house and make it adaptable to the wheelchairs. But what is that going to mean for the family? Does that mean that the one parent who's not living there is not going to be able to see the child as much? So they had to come, they had to be able to think creatively. They had to be able to really take a look at what was possible, what their options and alternatives were, in order for them to come up with a solution that met everybody's needs and that enabled the child to have a close relationship with both parents within the bounds of what they could afford to do. So that's a very typical type of a dilemma that people find themselves in when they're divorcing and they have a child with disabilities. And mediation provides the perfect format, perfect forum for people to explore creative solutions, in which they ultimately did come up with. Um, and then lastly, I would say, I've been involved in situations where it was not the child who had a disability, but it was one of the mediation participants who did. Two adults going through divorce, have no children, but one of the spouses has a traumatic brain injury that impedes and affects their ability to attend for long periods of time. They wanted to use mediation to go through their divorce, but typical mediation session is about 2 hours long, often on Zoom. And one of the two of them was not able to attend for that long. They couldn't do a 2 hour mediation session. So we worked with them. We offered the opportunity to do shorter sessions, right? We talked with them about what sorts of things that they would need to be able to participate fully in the process. We were able to have some kind of a dialogue. Um, and because it's a pretty adaptable process, we were able to offer the opportunity to go through divorce efficiently, to not have to go to court, but to do it in a way that both people could participate in. So I could go on and on. There's lots of examples that I've come across, but those are just three.
It's always great to hear you tell these stories because, one of the messages that I hope people are taking away from this conversation is the importance of having a mediator who has the right attitude and has that attitude that you've been sharing of let's all come together, let's work together, let's try to be flexible and adaptable and work this out in a solution focused mindset that isn't stigmatizing to the people with disabilities and is understanding that people are coming in perhaps with different needs and limitations, and that's not something to be afraid of if you're the mediator, but that's something to welcome, and to really stay focused on that kind of positive orientation. So that is not always the case, and I'm going to be sharing some more information about how you can understand what your rights are as someone who has a disability and how to what to look for when you're looking for a mediator to make sure you're finding someone who won't put up a fight about changing their 2 hour long session and making it a different format for you, and who will be understanding and warm and positively focused when things come up like some of the unique circumstances you brought up, because people had as part of their consideration, as part of their divorce, that they were navigating disability issues, whether it's theirs or their child. So thank you. I just want to say thank you as as a person with disability. It means a lot to me to just hear your attitude, and it always does when we speak. Just in the last couple of minutes, before I go on to share with people what I think is important that they look for when they pick a mediator and understand how to deal with some of the challenges that might arise when they go through the process, because there is a lot of unfortunate paternalism, stigma, prejudice, assumptions, etc. What do you think, Josh, as our final question, is important for a mediator so that they can be accessible and empowering when working with parties with disabilities?
So a couple of key things to keep in mind. I think it's very helpful for mediators to really go back and remember why it is that they became mediators and what the sort of core principles and values of mediation are. Because in the end, spoiler alert, those are going to be the same skills that you're going to need to be a good mediator generally, are the same ones that you're going to need to be a good mediator for people with disabilities. But let me give you a couple of really specific examples. First is flexibility. Flexibility in your thinking, right? About your process and in your openness to adapt your process to individual needs. The more rigid we are in how we do things and in how we approach people, um, the more narrow a range of people we're going to feel comfortable working with. But the more flexible we can be in our thinking and our willingness to change and to adapt and to go with the flow of different personalities, different people, different circumstances, um, issues that we may have never encountered before, an openness to encountering newness, new things is very important. And again, it's very helpful because it makes situations that are different a little less scary and a little bit more exciting and a little bit more interesting and um, satisfying to lean into rather than sort of being so tied to one way of doing things and one type of situation that you're comfortable working with. So flexibility is really, really helpful. Um, Another thing, and this is something, Dan, that I've learned a lot from you. I mean, listen, to be fair, in one of those situations that I mentioned before, Dan, you were very helpful to me. I called you and I asked to talk to you about kind of how to handle a situation, and you were really, really helpful. Part of that involves what I would call honest self-reflection. I think it's really important for all of us as mediators. I do this a lot to really be honest with yourself about your own biases, your own preconceived notions or understandings or misunderstandings about disabilities generally, about specific disabilities themselves. So sometimes we walk around with all kinds of ideas and thoughts, sometimes not very positive ones, about people with certain types of disabilities, maybe people who have mental illness or certain types of mental illnesses. Being honest with ourselves about those preconceived ideas, those judgments, is really important. Not to punish ourselves or to wag a finger at ourselves, but to be aware that those are there and to know that we have to actively engage with that if we want to be true to our values as mediators. So honest self-reflection. Um,
So thank you.
the,
Thank you. Oh, you have one more?
yeah, one last one.
Okay.
One last one. I think being committed to ongoing learning, always being open to learning more, um, going to CLEs like this, going to to seminars and webinars like this, talking and learning from other people from their experiences, picking up the phone and calling or zooming with someone like Dan who can share experiences and you can be open to learning. If you're open to learning, it's sort of like part of being flexible. It not only helps you help people better and make you less afraid to lean into these cases, but it's very enriching. And it's why a lot of us got into this profession in the first place. So um, those would be my three things: flexibility, be honest with yourself, and be committed to continued learning.
Well, thank you very much for sharing all that. So you can't be here with us for the rest of the day today, but I hope everyone can still give you a round of applause and thank you for being here. I am really honored to be able to have this conversation with you and share with you, and I'm excited to pick up and tell people really what to look for to make sure that when you go to mediation, they find someone like you. And I think everyone can hear from the way you talk about it in the conversation, your enthusiasm, your openness, your humbleness, like you said, to have that self-reflection, your desire to learn. That's what we should be seeing from everyone. And sometimes that's not the case, or sometimes people haven't learned enough and they're not open enough yet. And so that's part of what I'm going to segue to focus on teaching people when they're going and looking for a mediator. How do you make sure that that process is going well for you, and what do you do if you do accidentally, or if you encounter someone who may not mean to, but they may have some bias or a prejudice, they may not have done the learning they need to do to really be empowering when parties or their children or whoever has a disability. So I'm going to continue from there, but I'll say again, I hope everyone gives you a big round of applause, and thank you so much for all the work you do, and especially for modeling the attitude and the presence of what it looks like when you do have that truly flexible, engaged mediator who is ready to be accessible to parties with disabilities. So thank you again.
Thank you, Dan, and thank you for all of your tremendous advocacy on this issue. You were really, everyone's very fortunate to have this opportunity to learn from you today. There are too few people like you doing this work as advocates. So um, you're getting a round of applause from me too. Thanks a lot. I appreciate it.
Well, thank you. Hi, everybody. I am now here in person, and we did a bad job making the transition smooth because I've gotten a haircut. So obviously, that was a pre-recorded program, but Josh wishes that he could have been here. Um, so before I go into presenting some more information to help all of you in thinking about mediation and pursuing a mediator, I want to open this up for any questions following the video. I already see one from Joanne in the chat. So I will start by answering that question, but I invite anyone who has um, any feedback or questions that they want to discuss to please let us know now, and we'll take questions throughout as well. So before I get into any more material, um, Joanne, I see that you're unmuted. So do you want to read your question or no? I could.
Yes, can
Oh,
you hear me?
yes.
Okay. My question is that I know in certain cases, whether there's a person who with a disability or not, probably should not go through mediation. The one that immediately comes to mind is, say, a person with a disability who is a victim of domestic violence. Putting them in mediation could result in more trauma towards them. So my question was, besides that kind of scenario, what other areas would you recommend people not going through mediation?
Um, So that's a great question. And it's true that it's a very common idea that when there is a history of intimate partner violence, that they don't try mediation, but that's not always the case. So
If
I'll
you
start.
talk to the domestic um, um, abuse, violence against women community, they always recommend against it you, because there's a possibility that you end up hurting the person more than before. So you're getting a conflict here in recommendations.
Yeah, I'm just telling you that there are people who I'm not telling you that you should do mediation with domestic violence. I'm saying that there are mediators and there are programs that have tried to do mediations with domestic violence, and that's still going on. And there is still some debate. What I was going to say was, um, it's an interesting question comparing it to that because the theory that you're describing is even if a person who has experienced intimate partner violence was choosing to do the mediation, it should be rejected because they're not in a good place to be able to make their own decision and freely decide whether to do it or not. In part because maybe there's been many years of a power imbalance where they've been dominated by another person, and so they don't really fully have the freedom to be able to make their own choices. Um, and in part because maybe, um, there's a theory that what's best for them is not to be exposed to more of that trauma when they go to the mediation. So what you're saying and what I was saying is, that is the popular guidance. What's interesting about it in the context of us today is there's all, the the general premise of mediation is that the parties decide whether or not to go to mediation, and the parties decide um, whether um, the parties decide whether it's safe for them or not. And so, whenever there's a time that a mediator is saying, you know what, I don't think this is suitable for you, that's an interesting place to be because a mediator's job is supposed to be listening to the parties. And one time that mediators also might say that is there are times that mediators will, and this is work that I do, will think that mediation may not be appropriate because someone has a disability. And so, you know, and that's different by center, but one idea is there's stereotypes that some disabilities are not able to make their own, or some people with disabilities are not able to make their own decisions. So I do a lot of work myself to try to get people to remove policies that are screening out people with certain disabilities by suggesting that they may not be suitable to participate in mediation because they have a mental illness or a psychiatric disability like mine. And actually, in October, I successfully advocated that the Michigan State Court change their intimate partner violence screener for mediation. They had a screener that was checking to see if someone had experienced intimate partner violence and asked a number of questions about, awful things that may have happened. And then one of the questions was, by itself, a question that said, and do you think the person has a mental health problem, and do you have a mental health problem? um, that's not really an appropriate question for screening intimate partner violence to
I
assume.
agree with you. I agree with you.
Right.
That's not
But that's what was done, and so the court removed it. And there's other people who are doing this domestic violence screening. There's something called the MASIC screening instrument, and there's mediators who literally, while doing domestic violence screening, will have a question about whether someone has a mental illness. And I've been working to get them to remove them. So there is an interesting intersection here, but the bottom line is my personal view is that mediators should be leaving choices about whether a process is good for the parties or not up to those parties. And it is a little confusing to me, the logic. I understand the logic of this is a upsetting situation that could be triggering, but people have used that logic as well to say someone with a mental illness cannot handle participating in mediation, and so they should be screened out also. So it's just a tricky thing to do, in my opinion. And I would
so. So could I do a feedback real quick?
yes.
Generally, what happens, I've got several friends who work in the domestic violence field, is when they're suggested to do mediation, they ask the person who is the victim, do you think you can handle this? And if they say yes and they want to do it, they'll go ahead. But if they're not, then they have this conversation beforehand before they make the referral, instead of giving the total control from the perpetrator to the victim. They give the victim the first chance to say yay or nay.
Yeah, but that's different than that's saying you can do it if you feel comfortable.
Hmm.
And so, but there's some places that don't let you do that, and they'll say they'll do an intimate partner violence screen, and they'll just say, these services are not appropriate for mediation. And so the way you described it, I think, is the more empowering way. But I just was saying, you started by saying mediation may not be the best option for certain cases, and I thought that was an interesting beginning because I've been fighting within the mediation community to get people to realize don't assume mediation is not appropriate just because you have some preconceived notions about someone's disability experiences or situation. And so that's why when Josh and I had the conversation, um, I was mentioning, it's important that when you go to mediation, you have some vetting process of your own to make sure you have found a mediator that isn't going to step in some kind of domineering way based on their notions of what's possible or not possible for someone who has a disability. And so, when you ask the question of cases where you shouldn't do a mediation with people with disabilities, um, my my answer to that is, I believe a person with a disability could benefit from all kinds of mediation, but they should be checking that the process itself is not riddled with possible biases, because when we're in a world where unfortunately some of these mediators are being taught to check for, I had somebody where I was at a conference for mediators once, and I was trying to explain to them, you should make plans to respond to challenging behaviors. You shouldn't assume someone with a mental illness like mine has a challenging behavior. And this person said that the first thing they would do if they heard someone had a mental illness like mine is they would do a capacity screen and check that person for capacity. Now, I said to them, um, do you screen everyone? They said, no, they would just screen based on knowing the diagnosis. And I said, that's wrong. That's very demeaning. And I spent like, 30 minutes arguing with this person and, trying to get them to not do it. And unfortunately, there's a lot of biases. So this is a good, that's what I would suggest you look out for. My other initial thought was just, I give an example a lot about divorce mediation because I try to explain why it's important that mediators know not to pry about someone's disability if the person doesn't want to disclose it. Unfortunately, in divorces, when there's a custody dispute and there's a parent with a mental illness like mine, like my bipolar disorder, there's good odds that there will be bias that will presume that the person with the mental health problem is an unfit parent. There's a lot of statutes in different states that mandate judges to consider parental mental health, and sometimes it's not a matter of screening someone out, but it's just a matter of asking a lot of questions. And I've been trying to teach the mediators, you're not supposed to ask about someone's disability. So if I'm going to a divorce and my wife says, Dan doesn't seem like himself, and I don't know if he's still taking his medication, and he has a serious mental illness, he's been hospitalized 5 times, is that going to make my mediator all of a sudden look at me like I'm a ticking time bomb and start asking me a bunch of questions that are really not appropriate and make me feel terrible and disempowered and judged in the mediation? And then I'm left trying to prove that that I'm a fit parent because I don't want to lose custody of my children because of disability stereotypes. So my suggestion is, that I think a mediation can be good or bad in a lot of situations. But in that divorce example I'm giving, I usually share it because I want people to understand how scary it can be if someone's trying to potentially, use your disability against you during a mediation and you don't have a sensitive mediator. So that's why I was saying in the interview, Josh is a very attentive person to trying to make sure there are no stereotypes, et cetera. And as he said, he's not perfect, but he's trying. I would suggest people know that they should be checking their mediator to make sure they feel comfortable with that mediator and understand that there may be problems. And so it's important to really look out for this kind of stuff because a mediator is helping you through very important matters in your life. Like what I mentioned, like this is going to decide in the divorce mediation, the permanent custody situation, for my family in that hypothetical. So I think it's important that just people be aware of some of the ways a mediator that isn't like Josh could inadvertently hurt you in any process. Um, so and so I see, Joanne, you were adding about the divorce example in the chat. So yeah, I mean, this is a common issue. I've just published an article about using labels in family court cases. But anyway, if people have other questions, you should ask them. You could put them in the chat, or we could do a dialogue. Otherwise, I have some material that I was just going to share. Some of the issues that I think are important for someone with a disability to know when they're engaging in a conflict situation and considering a mediator. So I'm gonna move forward and share my screen to share that. But please feel free to ask more questions. I'll be watching the chat while I'm presenting. Um, and the two areas that I was anchored to when preparing for this are conflicts related to reasonable accommodations, meaning that you've asked for something to be changed and the person's not changing them. And then in general, conflicts related to discrimination. What does it mean when someone's thinking that there's discrimination? I'll also, before I get started, I'll share. There's lots of ways that we can think about disability and mediation. So one is there's all types of mediation, like I just mentioned, divorce, that are happening all the time, and they're not specifically cases about the disability that somebody has. They're just normal cases, and a person with a disability is going to that mediation for something that's going on. Maybe they have a community mediation with their neighbor, or divorce mediation, or some kind of contract negotiation mediation. And it's just a question of, is this process going to be good for me? It's a normal mediation process, but I have a disability and I don't know if there's going to be biases, et cetera. And as I just shared with the divorce example, there's profound chances in that where biases can come up and have a big outcome. And that is not really a mediation that's about the disability. It's about the divorce. Then there's mediations that are about a disability. So you'll have mediations where schools and parents are deciding an individualized education plan, like a special education mediation. I just gave a presentation last month with someone from the Equal Employment Opportunity Commission, where they have mediations where someone was, terminated or had a bad outcome at work, and they filed a discrimination complaint based on their disability. So those are times where the actual subject of the mediation is based on someone's disability. So there's a lot of, you know, ideas about, what kind of mediation case would you bring? Really, if you're a person living with a disability, my recommendation is there's all types of cases you'd have, and it's not about the type of case that's the issue. It's about how you're going to be educated before you go to the mediation process, so you understand what your rights are as a person in mediation. A lot of people go to mediation, they don't know that they can leave at any time. And most situations, if you're not allowed to leave at any time, it's not true mediation, because mediation is supposed to be your own choice. So a lot of people, haven't fully, whether they have a disability or not, they don't understand this is their process. It's supposed to happen their way. The mediator works for you, and their job is to support each party's decisions, and they don't really have authority over anyone. But it's easy for people to not know this about mediation, and sometimes there's mediators who are acting with some bravado, where they are very firm, and they don't really look like they are listening to you. They look like they're directive. There's a term, directive. Um, but underneath mediation, all of the power is supposed to be with the parties, and the mediator's duty is supposed to be impartial across the two parties. So they're not supposed to know anybody outside of this. There's a lot of places where, like in an organization, like the HR person who knows everybody might do a mediation. That's not really a normal mediation. The HR person works for the company. There's a lot of bias there. But the mediator is supposed to support the parties' decisions, and they're supposed to be impartial. And unfortunately, in my experience and in the work that I do, a lot of mediators have biases related to disability. I would say more often they are paternalistic biases, thinking that they have to go overboard trying to help someone, and not realizing that it's not their business to ask so many questions, or it's not their job. Um, you know, um, and but there's also biases that are not meant to try to help. There are biases where people have fear of dealing with someone with disability, where they're afraid to address the disability if it comes up because they feel awkward around someone with a disability, or they're actually afraid of the parties and they think that there's something alarming. And again, I come from a place of doing work about mental illness, and so there are there are fear-based reactions where people are thinking they'll screen someone out just based on having a mental illness. And I gave you that example already of that screening instrument that assumes that, and this is not, there's a lot of them that assumes that mental illness is like a negative score where you may be an intimate partner violence because someone has a mental illness. So let me, I'll keep watching the chat if there's more questions, and I see people giving feedback. I appreciate the feedback. Um, and I'll show you some more information about stuff to think about. But the two things that I think are, besides what I just shared about generally going to a mediator and making sure you feel like you are in control of the process and you are in the driver's seat, and making sure you feel like that person is doing their best to be fair. Those are the two big things that are the mediator's biggest job. Let me now walk through some of the things to think about related to reasonable accommodations and related to instances of discrimination. And that's important also because sometimes you may find yourself needing a reasonable accommodation with the mediator themselves. So let me pull this up. Um, okay, so this is a very crude summary of what a reasonable accommodation or modification is. But when anyone expresses a potential disability and asks for help related to it, it's considered a request for a disability accommodation. The reason I present it this way when I teach about it is because it's important that people understand that it requires both things: sharing a potential disability need and asking for help in order to be a request for disability accommodation. If I went to that divorce mediation and I said, my name is Dan, I have bipolar disorder, I do speaking about it, but I never said I needed anything. And they say, oh, let me sit down with you and figure out what you need for your bipolar disorder. That's not me having requested a accommodation or a modification. And that could be a sign of bias. So it's kind of a tricky thing to navigate, about where people don't really understand this, that a lot of people assume when they hear there's a disability, that must mean the person needs help. And, one of the things to think about, if someone's made that mistake, you don't necessarily have to not do the mediation, but you might want to say to them, I'd rather not answer those questions, and why don't we focus on the mediation? A lot of people, if you're in a standard intake, you may get railroaded into answering a lot of personal questions that you don't want to answer. And this is actually, by the way, in general in life, for someone with a disability, there's a lot of times where paperwork gets presented to someone that asks for information that you do not have to give, and it's illegal for them to ask for. So just that it's important to be mindful when you go through this process of just the fact that you have a disability does not mean someone's entitled to ask you a lot of information. A request for an accommodation or modification requires you to ask for something, and then they can ask you some questions. Some challenges accessing reasonable accommodations. First, a lot of there's a lot of misunderstandings about this, because I don't think people really have thought about how hard it is for someone to raise their hand at work or at school or going to a visit and say, what, I have this disability and I need something changed. But the first barrier is self-stigma. So a lot of people are out there acting like someone's trying to get a perk, and you'll have mediations where people at the EEOC are debating whether someone needs the accommodation without even necessarily understanding it was a big deal for someone to ask for one. A lot of people, like I'll say for myself, don't want to see yourself as vulnerable or limited. I didn't ask for these kinds of accommodations for decades for that reason. There can be a sense of shame around being different or needing something different, and people may not want to contact someone and say they need something changed because they just want to feel like the world is meant for them. And so already before you even get to the point of asking, there's a lot of um, baggage there that you would hope a mediator would be able to understand when there's a conflict of some of these kinds of um, personal experiences of how challenging it can be just to ask. There's also reasonable fears of backlash from others having stigma and confusion. And unfortunately, I'm going to show you some information. There's a lot of times people do have backlash when they seek an accommodation. That's why there's the EEOC cases and stuff. So it makes sense that people, have a negative attitude for even asking sometimes. Then once someone does ask, um, there's logistical burdens that may come up that make the process more difficult than it really has to be. And under the ADA, there's no mandate that someone has to jump through a lot of hoops in order to get their accommodation. It was created in part to make it easy for someone to ask for reasonable accommodation. But a lot of people, companies, schools, have created these detailed processes as a way to protect themselves from liability that put a lot of logistical burdens on someone who is seeking an accommodation. And some of the barriers may be the paperwork they have to do, the like I mentioned before, the inquiries. They have a right when you ask for an accommodation to ask for information, but not as much information as a lot of people ask for. Those people might have an internal review and discussion process. They may have some standing policies they tell you that of what they will and won't do as a reasonable accommodation. But that may not be a binding thing under the law. That's just what they do. You may get your accommodation denied. It may be denied because they say it's a hardship for them to do it. That's one way. That is a threat to others, not meaning you're threatening people, but just that it hurts other people, or that it's an alteration. Um, and there may be challenges complaining. I actually, at this moment, am involved. I've written a book published by the American Bar Association, but the general counsel's office at the American Bar Association told me that they don't believe they have to follow the ADA because they see themselves as a private club. And there is an exemption um, to the Civil Rights Act and the Americans with Disabilities Act that allows private clubs under their First Amendment right to assemble to turn people away based on, you know, um, race, disability, et cetera. And so they don't have to follow the laws. This is a whole mess I'm dealing with them. But the point I'm trying to make is people will people will make it hard. In that situation, my request was just that they let me know if they got my emails and let me know when to get an answer because of my mental illness, because I need structure in my communication. And this is what they came up with denial. It's not even on this list. It's a new one I have to add of trying to be a private club. So people coming in with these conflicts. One of the goals I have is to help people have more empathy of how hard it is on the side of the person who has a disability and is navigating these barriers to accommodation. I mean, you're an individual and you have a disability limitation. You need to get this addressed to work or go to school, or whatever. And you're dealing with an institution that has a team of people whose job is to argue with you, and they don't have any immediate need for anything because they don't they're not the ones with a disability limitation that's making it hard for them to do their work or go to school. So um, a mediator should be there in a way to listen to what the party's going through and help both sides get surfaced in a conversation, and help ideally to bring some of that human experience in. So if there's been a conflict, you'd help the person who's asking for the accommodation to understand that the person they're dealing with, may have a lot of pressure on them at their institution, and they don't have the authority to make changes, and that person may care to help them, but may be limited in what they can do because they just are one cog in the machine. And on the flip side, the mediator might help the person from the institution understand the humanity and what the person's going through, who has the disability. So that's the value here. There's another category of challenges, by the way, of backlash, which is after someone gets the accommodation, there may be problems where the institution underperforms in dealing and giving it. There's different impressions of acceptable alternatives, so that it's not the what the person wanted. That person is now visible. The person who has a disability, if it wasn't visible before, um, and they may be set apart from other people. There may be technical limitations and errors along the way. That person may have a tone, the institution may have a tone expecting you to be grateful for the accommodation. And there may be actual backlashes. So I had supported one person who got a Zoom video accommodation, and then their classmates on the class email list said that, sent an email saying they were using their disability to get unfair advantages. So there's a lot of problems that can come up. And the hope would be that a mediator would be there as someone who has that empathy, but also awareness about respecting people's rights. So to empower the person with the disability by having a conversation that treats the person with respect and gets people to understand these different perspectives. I see a question in the chat that said, um, so this question was asking, I mentioned that I needed structure in my communication. That resonates in a way that I'm trying to get support in my job too. Is there any way you'd be able to explain what that means and how do you ask for that? So I'm going to put my email in the chat. All of you are free, and I encourage you to contact me anytime, and I'm happy to talk to you more. I can't do this whole thing from the program, but basically, what happens is these issues of people's rights under the ADA are not so clear cut because the ADA is written very broadly. It doesn't list what disabilities count or don't count. Everything's a question of whether the person really has a disability, and then whether this accommodation is related, and then whether it's something that the place has to do. And so, for me, I have, the question was, what is the thing that I'm asking for? I have emotion dysregulation related to my mood disorder or bipolar disorder. Everybody in the world probably gets upset when they are ghosted and they don't get answers from someone, and that's normal in a lot of places. I am not a quote unquote normal person because I have a significant disability. I've been hospitalized 5 times from the breakdowns that happen from my bipolar disorder. So I try to request that people pay extra attention to me if they're not communicating well. And I say to them, I end up having obsessive and intrusive thoughts if I don't hear back from people about whether to follow up or not. And I'm afraid because some people in the past have stigmatized me and accused me of being a stalker using mental illness stigmas. So I would appreciate if you can let me know if you received my message, and let me know when you're planning to get back to me if you are. So that way I can plan it and not be spending every day obsessive and decompensating with the emotional regulation. So that's when I said I need structure in my communication, that's something I asked for. People are not used to receiving that kind of accommodation request. A lot of the accommodation requests that someone might ask for a psychiatric disability, there's a lot of things that people could ask for, but I don't think we live in a climate where someone even thinks it's possible to ask for. Even though in theory, what I just described is very easy for people to do, but in practice, I've had some bad reactions to it. Sometimes I've had good reactions. So, but you can imagine, there's a lot of conflicts that can come from this process with accommodations. I actually have a study that I've been working on with data from the Bazelon Center for Mental Health Law, where over 400 students detailed discrimination they experienced in higher education for their psychiatric disabilities. And I prepared a chart that walks through all the reasons they gave up trying to get a reasonable accommodation. And the themes that I found were hopelessness, where they didn't think there was any hope anyway, lack of knowledge that they could keep trying, burdens from their disability circumstances, meaning they were too affected by what was going on for them, they couldn't keep contacting the school to ask. Fear of retaliation. People told stories of seeing people having experienced retaliation, self stigma and self blame, um, poor implementation of the actual accommodation. So there was no point. And then delays and non response. So I just want you to see that this is a real problem. And the the hope would be a mediator can help, but the mediator also, would hopefully understand there's a lot of power imbalances here. So it's an individual person versus a big institution. The practical reality is it would be very difficult for someone to launch a litigation about this because it takes a long time, it takes a huge toll, and the odds might not be that great to prevail, and it may be hard to find an attorney. If I spoke to one disability rights attorney, a prominent one, who said unless somebody's fired, um, they don't see how someone would take the case because there wouldn't be any money in it for them to do that kind of advocacy. So that's another value of mediation is there's some of these situations that might not ever make it to a functional court case, but maybe if people would agree and go to the mediation, you can get something done. Um, so that's all I'm going to talk about with reasonable accommodations. I wanted to talk about discrimination as well, but before I do, does anyone have any more questions about reasonable accommodations? The value with mediation. Um, what to look for. Um, I'm also going to prepare a follow-up resource to send, if not today, then sometime this week, that gives you some guidance about what to look for with mediators and some of the themes that we're talking about. Now, I don't have it to share at this moment, but I'm going to put that together for you. So you'll be able to get that, and then when you get that, you'll all have my email address as well, like I put in the chat. So you can follow up with me from there. So um, the last thing I wanted to talk about, we have about 15 minutes left, is okay. Yes, Sarah is absolutely right to recommend askjan.org as a place to learn about accommodations. There's a lot of great stuff there. And you can search by condition as well as by the actual functional limitation that you're having, to get some ideas. And that's a service that's funded by the Department of Labor. Okay, so basically reasonable accommodations when you ask for something to be changed, but you're also supposed to be protected from stigma and discrimination and microaggressions to different degrees. So let me explain that. So this is a handout that I have, which I can share with everybody. Noticing stigma, discriminations, and microaggressions just in day-to-day life. To look for stigma and microaggressions, did someone make a comment or action containing an implicit message implying any of the following is associated with a disability? And there's things like, I mentioned some of these: dangerousness, inferiority, helplessness, and vandalization, minimization of seriousness, social undesirability or exclusion, or a burden. Now, having these attitudes and making a microaggression is not, by itself usually something illegal, but it could become evidence. You may find yourself in a mediation having debates about whether someone has a bias, and citing some of these kinds of comments, and it could be used to help prove that someone is acting with a bias when they're doing things like promoting one person but not another, or firing someone, or any hostile work environment stuff. Then you've got invasion of privacy is a possible problem. Did someone ask a question that invaded your privacy by seeking answers about the nature or severity of your disability? The EEOC, the Equal Employment Opportunity Commission, has a good handout that says questions you could or can ask at work. Eligibility criteria: is there a screening process to deny access to services or provide different services? based on a person seeming to have a disability or actually having one. These are all the kinds of conflicts where if there was an allegation of discrimination, these are the kinds of things that would be coming up. The last one is just general disparate treatment. Is someone providing you unequal treatment relative to another person based on their belief or knowledge that you have a disability? So these are the kinds of things that, in my life, when someone asks me, do you have a framework to understand what stigma is or what's going on? I always talk about denied reasonable accommodations, disparate treatment, screening through eligibility criteria, invading privacy, and then these microaggressions. And those are the things I list as problems. So these are things that you might see come up where a mediator may have to figure out how to navigate it when somebody does that. I've actually, I have a book about mental health and conflicts that a lot of mediators can rely on. And in it, there's a script about what do you do when one person accuses another of having, a mental illness, and tries to disparage them because, should the mediator respond and comment on it? What do they do? These are all tricky issues that can come up in mediation. There are things that you can look for. Now, one thing that I have been working on is getting mediators specifically to respond to mental illness stigma, but it's applicable to all disabilities as well. I'm doing work with the Department of um, Mental Health in New York State. And so I've been creating tools to help anyone use conflict resolution processes and practices to try to work through stigma. So this is a model that I'm going to be sharing with more mediators to use as well. The first thing we talk about is trying to raise awareness of what stigma might look like in practice, which is having choices taken away from you. An organization is not accessible to your disability needs. People are not inviting you to social events. You're being insulted with rude names or microaggressions. This is part of a social media campaign we're doing in New York. And then we have these 5 steps to respond to stigma. And there's a whole model of what to do with each of these steps, but you would clarify whether something stigmatizing really occurred is the first step. Then cope with the trauma of having experienced the stigma, because whatever the resolution is, it's still uncomfortable. This happened. Collect evidence of what happened as you go through the process and sort through it. Cultivate support options and seek support, and then consider your rights, options, and limitations and decide the next steps. So this is a model that if you look through it, and we had a bunch of mediators attend some of these trainings, it matches what a mediator would be doing during a mediation in a lot of ways, because you're going to talk to each other and clarify what happened. That mediator is there as a third person who hopefully is going to be empowering to all the parties. So it feels like it's a place where they can be safe and cope and not be re-traumatized. So that's the ideal of how a mediation could go when this kind of topic is coming up, where they're having a mediation, where let's say the EEOC mediation about a wrongful termination due to disability discrimination. They may be talking with the mediator, and in that case, I believe they do shuttle diplomacy a lot at the EEOC, so they may not all be together. There's a lot of differences that you may find when you go to different kinds of mediators, and that's why my goal today has been to give you some introduction to the things to look for, and I will share some tools to help you you yourself consider your options when making these mediation referrals and checking with mediators. One of my goals has been to give people tools they can bring with them. So if their mediator may or may not have a problem, they get given instructions to address it. So we've got about 7 minutes left. I'm going to leave this up here in case people want my email address. Again, I'm happy to be a resource, and I will be sending some resources later in the week. I'll take more questions if anyone has them. And I see one right now. Could an example of the stigma burden of being in a situation where you're concerned about something your boss said, looking for a mediator, but not trying to get your boss into trouble, and the upper level boss, the rest of the person to HR as a way to write out the supervisor? That's a very good point. I'm not sure I fully understand all the twists and turns. in the story, but you're absolutely right that, I actually was brought in to do a mediation that I think was like this, where there can be a stigma in a workplace that there even was a mediation. So there's people who do not want it going up to their boss. They need to bring in a mediator, and it can be part of a record that's created. Like if a if anyone here has heard of a performance improvement plan, a PIP that a company might do where they decide they want to fire someone, and so they schedule a meeting to give them performance improvement plan, but really the plan is to over time to document that they had cause to fire the person. The fact that someone went to mediation could be seen as cause for some kind of discipline, and so um, asking for mediation could be seen as something that's escalating and inflammatory. Um, and there's all this politics, I guess, around how you use the mediation. So it's not sort of like a product off the shelf. The way it's going to work is different people are going to have different impressions of what's going on at the mediation. Um, and the mediation is supposed to be confidential, but the fact of the mediation and the disposition of the mediation probably won't end up being confidential. And there's a lot that can happen. I have heard of situations where someone has done a mediation, um, hoping to create stress for the other person to trigger their psychiatric disability during the mediation. So that way it's proof that there's a problem that they have with that person. So I've heard those kinds of stories reported to me when I've been collecting information about bias with disability. So mediation, you know, is a great concept and a great process. The people doing the mediations, you want to find a really good mediator because the field itself is not so well regulated. There's lots of different people, and not everybody is equipped for these kinds of situations. I was excited to start our program by interviewing Josh because he is very focused on serving parties with disabilities, but also he is just very receptive to being open to feedback and learning, like he shared. Um, and I think that my hope will be that the resources I'm going to finalize and get to you will help you if you're going to be looking for a mediator and also communicating with that mediator to make sure that they understand your boundaries. I see another question here. What are your thoughts on a person with disabilities having a case manager present during a mediation? That really is up to the person. So most mediation processes that I have seen, people are allowed to bring support people with them if the other party agrees. I've actually done mediations where, but we couldn't do the mediation because we had to first mediate about whether the person's support person would come. There's some mediators who would say, like a lot of times people bring their attorneys to mediation, and mediators feel like that's uncomfortable sometimes. They'd rather hear from the party themselves, not the lawyer. It should be the party's choice of who they're bringing, and then both parties should be agreeing on, whether the person's brought or not, because it's a voluntary process for both parties. So, assuming the other side agrees, I think it's helpful for someone to bring whatever support person they want. That's another thing that people should be aware of. In general, the field of mediation is biased toward talking in a certain way and not always as accessible to other styles, including even bringing another person. I see someone ask the question of, well, what if someone's afraid that it'll look like there's stigma towards bringing someone with them to the mediation? That's a good point, and there's I don't have an easy answer to how it works with there being stigma to that. My reaction is that's another thing that unfortunately is so sad, that someone with a disability, like I gave the example of the hypothetical divorce, you feel like you need to prove yourself. And the reality is we live in a society where there are stigmas towards disabilities. That's why I do a lot of the work I do. So I would never tell someone, don't be silly, don't worry, just do what, I would say you make a choice of dealing with the practical reality of what's going on. You're not going to get a perfect mediator. You decide if you want to bring a support person or not, and understand that maybe it will lead to some stigma. And my philosophy is that people need tools to cope with what's actually happening, and not to plan for living the fantasy of how it should be happening. So that's why I'm going to send you all tools that are designed to help deal with the reality that there's bias and problems amongst some mediators, as opposed to a handout that just lists referrals and assumes everything's going to go great. But that's, I appreciate you sharing that story, and I think you're right that there would be potential stigma, and the hope is, I mean, the biggest hope for mediation is that it reduces the stress of prolonged conflicts, reduces the escalation to litigation, and increases a feeling of empowerment for someone who has a disability and is experiencing the burdens of stigma and other kinds of burdens that maybe can be lessened with a competent mediator. And that doesn't mean that I've learned this myself with all my work. All the people who I do great work with still have some mental illness stigma because it's so embedded in our society. So my motto is I shouldn't expect everyone to get 100 on every test, and I should be appreciative, in my view. This is just my philosophy. If someone's getting a 70 or if someone's trying. So the biggest thing to look for if you're going to pick a mediator is someone who looks like they're trying their best, and you trust that, and you understand that they can't fix the whole world. But I know I'm over time now, so I'll stop it there. If anyone has more questions, you can email me, and I will be sending out the resources, by the end of the week with some tools to help with all this.
All right. Well, thank you so much, Dan. Really appreciated this wonderful and nuanced discussion and all the work that you're doing in this area. Can we give Dan and Josh both a great round of applause?
Thank you very much.
All right. Thank you again. All right. So for everyone that's with us in person as well as online, we are going to switch to some closing remarks. So we're going to close out the breakout room virtually and head over to the main room in person as well. And we'll join you again in just a moment.